Please welcome Justice T.S. Thakur, who is now the Honorable Chief Justice of India, while I request him to come and deliver his inaugural address.
Ladies and gentlemen, I'm heading an institution in this country which has something like 15,000 courts spread over the length and breadth of this great nation. We have something like 15,000 judges at the lower level. There are about 800 judges at the High Court level, and as most of you know, the Supreme Court comprises 30 judges besides the Chief Justice. Now, in a country which has a population of 1.25 billion and which is one of the fastest growing economies in the world, in a country which is poised to be a superpower in the years to come, in a country that is resurgent in terms of economic growth, development, progress, we are bound to have our challenges. And when we talk of challenges, judiciary is not alone, and judiciary is not isolated or is not exempt from those challenges. In fact, our challenges also multiply manifold when the country progresses. Partly because when the country progresses on other fronts and the parliament makes laws after laws, it results in a spurt, a great spurt in litigation as well. But we have been repeatedly saying that whenever you enact new laws, whenever you bring new legislations, you must also simultaneously assess the impact which those legislations will have on litigation in courts, and correspondingly or proportionately provide for remedial measures, so that when you make laws, you anticipate you anticipate disputes, you anticipate litigation in regard to those laws. You must also simultaneously provide for mechanisms by adding to judicial infrastructure, creating new posts, creating new opportunities, and therefore offset the imbalance that is likely to happen. But that has not taken off. It has not happened. Today, we continue to add to laws, and the laws continue to add to litigation, and the litigation continues burdening the courts, that we have a very, very large number of cases pending all over the country. When we talk of arrears, we talk only of arrears, the cases that have accumulated. We don't talk of what we have already disposed of or what we dispose of every year. How many of you know that the Indian judiciary handles or processes 5 crore cases a year? How many of you know that out of those 5 crore, 2 crore cases are actually disposed of by the Indian judiciary, despite all problems in infrastructure, problems of filling up of vacancy, non-creation of posts, and so on. And what remains with us perennially is an area of nearly 3 crore cases. Now, most of our critics, and we have many, I must say, inside and outside the institution, our own system, maybe in the other wings of the government and the state, who tell us, you always keep pointing fingers at us. Why don't you settle your own house? Why don't you see that things move within your system? Our answer is, not all of these 3 crore cases are arrears. 3 crore cases are pending, and at any given point of time in a country like this, a vast country like this, a country which is the most populous next only to China, There have to be some cases that will remain pending. After all, there are 15,000 courts that are functioning. So, a case can be considered to be in arrears only if the case has gone beyond the period that is determined for its disposal. If you have a civil suit, you must concede to the judicial system a specific period within which it must be disposed of. A civil suit, if is not disposed of within that period, one can say it has overshot its lifespan and therefore it is an arrear. But at any given point of time, if a matter is filed, it is under process, the evidence has been recorded, cases are being, handled at various levels, you may not treat every case as a case that is in arrears. We have yet not fixed the gestation period for cases. We must first fix the lifespan of a case. The system must, looking to the nature of the case, determine as to within how much time should the case be decided, disposed of. And if you go beyond that, it can be considered as arrears. I would say that by the most conservative method of determining the age of a case, one could say that the number of cases that may be in arrears may be 1 crore of cases. Because 2 crores are in any case in the process, are in the churning pot. And therefore, nearly 1 crore cases could be said to be really in arrears. Now, those arrears are a matter of great concern for any sensitive system as ours, and we have taken several measures to remove those cases from the arrears list and give the speediest possible justice to people involved in those cases. Having said that, we would welcome a system that is alternative to our system of adjudication. We would welcome a system where people can go to a domestic tribunal like arbitration. We would welcome people choosing their own judges, agreeing to resolve their disputes with the help of those judges. We have absolutely no difficulty. Actually, we welcome these measures when parties agree for a reference to arbitration. We are supportive of arbitration because not only because it helps the parties in resolving things quickly, is relatively less expensive, less time consuming, but also because it relieves us of the burden of deciding those cases. So please rest assured that the judiciary, right from the top till the bottom, is always very, very supportive of arbitration as a means of resolution of conflicts. And therefore, we would do anything that will make effective this alternative mechanism of dispute resolution. There is absolutely no conflict of interest between judiciary as such and the arbitration, that part of the section of the society, for that matter, ICA or any other institutional arbitration, where you take over a part of our burden. So, whether it succeeds or not is not the point. I would say that whether you treat it as mediation or arbitration, the difference is very, very, very slight. In mediation, you try to persuade the parties towards a settlement. You push them towards a settlement. You make them understand the weaknesses and the strengths of their respective cases. In arbitration, you adjudicate upon the dispute. But both are domestic in nature. Both are outside the traditional court system. There are two lessons. One, that it is a divine function. To arbitrate or to mediate is a divine function. Even God himself has taken upon himself, you see, this function of trying to resolve conflict. And number two, never mind, even Lord Krishna failed in his attempt. If you fail, it doesn't make any difference. He failed. And number three, those of you who do not resolve it or who do not contribute to resolution, are not positive to this kind of a amicable resolution, are bound to face disaster and get annihilated, economically or otherwise. These are three very great lessons, I would say, that you draw from mythology. Having said that, I may tell you that 1940 Act, which was the precursor of the present 1996 Act, personally speaking, if you ask me as a lawyer, 1940 Act was a good act. It is an excellent piece of legislation. And the legal position stood settled. I tell you an instance. The Supreme Court had said, while interpreting Section 30 and 33 and the Arbitration Act 1940, that if you refer a specific question of law to an arbitrator, a specific question of law, and even if the arbitrator commits a mistake, answers it wrongly, the judgment is binding upon the parties. It may be an erroneous answer, but the court said, well, you have referred it to him, and therefore he is the last word, we will not interfere. The ancestral model, which we thought is a step forward, has not actually proved to be a step forward. Because instead of reducing the area of investigation post-award, it has widened the scope for investigation, widened the scope for interference by the courts. For instance, an award which is against public policy of India can be set aside. Now, what is public policy of India? There's no definition. Therefore, when the question arises, if an award is on the face of it patently illegal, is it public policy of India to uphold it? Answer is no. It is not public policy of India that any award which is illegal should be upheld. It must be set aside. Now, is it public policy of India that an award which is made without hearing the opposite side should be upheld? Answer is no. You can't make an award without hearing the opposite side. It is not public policy of India to make an ex parte award and uphold it. It's bad. It must be set aside. Is it public policy of India that the arbitrator does not apply his mind to the facts, to the law, to the evidence and makes an award? That the court should say, no, this is a good award because the arbitrator has made it? Is it public policy of India that a perverse award should be upheld? Answer is no. Public policy of India is that a perverse award cannot be upheld. So we will interfere. Is it public policy of India that a corrupt award, somebody who has been bribed, he's given an award? Is it public policy of India that a procured award for illegal or extraneous consideration should be upheld? Answer is no. Public policy of India is that this process of determination of rights and obligations of the parties must remain pure, pristine, unaffected by any extraneous consideration. Why? Because you may call it arbitration, but it is also a mechanism for administration of justice. The arbitrators are in the position of judges. They must be fair, they must apply their mind, they must be conscious of the law, they must appreciate the viewpoints of both the sides, they must be unbiased, and anything that is an aberration for a court will also be an aberration for the arbitrator. So what happens? An arbitrator goes and enjoys a dinner with an opposite party. An arbitrator goes and socializes with the opposite claimant. He has a friend with whom he associates, and the opposite party feels left out. He feels that this man is totally won over. Our greatest concern, if I may tell you, when we sit there to judge awards, is the integrity of the arbitrator. If you are satisfied, if the court is satisfied that the arbitrator is a man of impeccable honesty, we would do anything. We would lean in favor of the award, even if we find that, yes, on a very strict interpretation or on a very, very close scrutiny of the evidence, the arbitrator has committed an error. We would tend to uphold the award because we would then be confident that the award is honest. But if there is the slightest doubt, if I may say so, and I can say with no fear of contradiction, that honesty is not the monopoly of judges only. We don't say that in this entire system only judges are honest and the rest, everyone is a suspect. No. But experience has shown that in comparison to non-judicial arbitrators, judicial arbitrators have been more reliable and more credit-worthy in terms of their integrity. When we choose an arbitrator in the Supreme Court, the uppermost thing in our mind is this man really impeccable in his honesty? That is the uppermost thing. He may commit a mistake, but it must be an honest mistake. So whenever the issue, whether an arbitrator has made a right award or a wrong award, the first question that a judge asks is, who was the arbitrator? Who was the arbitrator? It is no reflection on an engineer. I know they're very distinguished engineers, they're very distinguished scientists who are acting as arbitrators. But the moment you are told that, well, it was somebody not really from the judicial fraternity, then there is that feeling that, well, is this an honest award? And the judicial mind starts working on it. You start suspecting, well, an award for 1,000 crores? God alone knows what has happened. So we start with that kind of a feeling. So I think one of the greatest challenges in any system for adjudication by arbitration is to ensure that the arbitrator is a man of impeccable honesty. That is the first and the foremost requirement for arbitration to succeed. The moment the court is satisfied that there can be no doubt about the honesty of this person, the court will certainly lean in favor of an award, even if on a very, very close and very, very careful scrutiny, it may like to disagree with the conclusion. Because then the court says, all right, well, Justice Nijjar has made this award. He is a man of impeccable honesty. Even if there are two views possible, we would not like to interfere. Let Justice Nijjar's view prevail. That is how we look at it. Now, what is happening? Why is in this country arbitration not flourishing? You have to see outside the country. I was speaking to Justice Ravindran, who is doing an arbitration in England. He said, there are two or things that distinguish the systems outside from India. One is the professional approach of the arbitrators. And mind you, remember Justice Nijjar has been doing arbitrations in India for the past about 2.5 years, 3 years now, and he's a very busy arbitrator. He's a man of great, ability and very, very competent, and he has experience with Indian arbitrators. He said, in India, an arbitrator says, yes, I will sit only for 2 hours. Beyond that, I will not sit. There is no professionalism in the arbitrators. He said, in London, I am sitting for 8 hours. Except, he says, half an hour when I go out to breathe in fresh air, we are all the time busy, engrossed, and parties are ready with their evidence, the lawyers are ready. It is not as though, you see, some senior lawyer, Mr. Mukul Rohtgi, will come, yes, my lord, I have a case in the Supreme Court, I can't come on this. You now post it on that day, or you see, tailor your proceedings to my requirement. No. There are lawyers. Somebody mentioned that you ought to have a bar, an arbitration bar. Yes, you may. You should develop a bar so that people don't say, no, I am busy in the High Court, I am busy in the Supreme Court, I have another matter listed there. You ought to be professional. The world is changing and people don't now, you see, the litigant doesn't have the patience. And if a litigant is paying a lawyer handsomely, there's no reason why the lawyer should just mark his presence and then go away and say, well, I am busy in the Supreme Court, therefore I can't, proceed with the arbitration. So lack of professionalism on the part of arbitrators and lawyers is bringing a bad name. If you really want to flourish in India in arbitrations, you ought to make yourself professional, professionally competitive with people from outside, and see the kind of professional dedication and commitment they show. A matter must finish once it starts. There is no question of postponing from one date to another date. It becomes oppressive for the parties as much as it becomes oppressive for the arbitrators to entertain such complaints. That there are many areas that within the arbitration law that require a relook. But what is heartening is that the government is conscious of this requirement. They have brought an ordinance, and that shows that they want to make changes, they want to make amends, things are moving, and the fact that they are making some amendments to the ordinance, as the minister, as you mentioned, has said that they need to make some amendments, also is very heartening. I think so long as people in the right places, and especially the government and the parliament, are sensitive to the need of the hour and the need for a change in the system, I think we can rise. Singapore is popular for arbitration. Why? Not because they have a beautiful building or they have good, technology to immediately give you copies of the statements or the depositions and so on. That can be done here in Delhi. There's no difficulty. It is the legal format that is important. And lastly, I think there is some deficit on our part also. I think the judiciary also needs to be sensitized to the need for a restrained interference insofar as arbitral awards are concerned. We need to appreciate that if parties have gone to a domestic forum, of course, one of the parties has lost, is bound to lose. Both parties are never happy in any adjudication. That is the the irony of the situation. That is why you find so many critics against judges, so many complaints, because both sides cannot walk out happily from a courtroom. One has to lose. It's very rarely that both are satisfied. It is only in a mediation where there is a amicable kind of a settlement where it's a win-win situation for both. Otherwise, in an arbitration award where you are awarding a hefty amount against a party, the party is bound to feel upset, is bound to challenge it, and is bound to find fault with everything that the arbitrator has done. And therefore, you need to have a proper format in the sense that the law must not provide for an open-ended challenge, like public policy of India is. Public policy of India, perversity, non-speaking award, ignoring evidence that is, admissible or is relevant, not considered, and so on and so forth. I think legal provisions and the process of the professionalization of the arbitrators and the lawyers, the integrity of the arbitrators, and the courts being sensitive to the need for promoting arbitration are some of the areas in which we need to give some attention. Thank you very much, and God bless you.